Lawyers/Solictors. What is the strangest or oddest law that has won a case for you? I got a pro bono client's removal by USCIS cancelled. He had a low-level drug possession conviction from the early 1980s. During that brief period, the active ingredient of Imodium was illegal under state law, but not federal law. So I successfully argued that they couldn't prove it wasn't a conviction for possession of a substance that was federally legal at the time, and as such was not subject to removal. The argument worked, and my guy went back to his business and his family. I had a case where a guy was charged for running a red light. The thing is, he'd been sitting at the lights for 5 minutes, and it hadn't changed. The wording of the specific section under which he was charged related to stop signs and traffic lights and referred to them as traffic regulation devices. I successfully argued that as the traffic light wasn't changing, it wasn't regulating traffic, and he got off. I couldn't believe it when the judge ruled in my favour. Neither could the police prosecute. 47. Who dots? 227. Restrictions on the use of automated telephone equipment. Law student working at law firm. We have a fax machine that gets tons of spam faxes. Our chief partner has a vendetta against spam, and he uses it to give us practice in researching and writing petitions. So we catalogue each fax, send replies to take us off the list, document everything and wait for them to fax us again. Then we follow up with a fake complaint and demand letter. A couple times this has ended up with the person getting mad and sending us retaliatory faxes, black sheets of paper. If they stop sending, we don't do anything. But we've gone to small claims a couple times and gotten $500 per page a couple times. We also got someone trying to sell drugs through fax, but we just turned it over to the police. The Canadian Interest Act specifies that all interest must be specified in per annum percentage. If it is not, it's struck down to 5%, simple interest per year. The number of lenders and creditors who try to pull off a 4% monthly compound interest, but aren't familiar with that provision of federal law. ... The weirdest case I have ever dealt with was Johnny Pelletier. 1999 . J. No. 1728. Got to. I did some research for this case when I was a law student. Some background. This was at a time when the Ontario Court of Appeal had held that, if there were any factual matters in dispute, a case could not be dismissed on summary judgment. That is not the case today. It was discovered that this position basically ruined summary judgment as a useful process, but it was at the time. In such a motion, all facts alleged by the plaintiff would be assumed to be true. What happened was this man sued, among others, the College of Dental Surgeons, for persecuting him and interfering in his ability to live as a generic marshal. The plaintiff claimed he had been cloned from space debris NASA found in the 1960s. He claimed he had a genetic test to prove this, but it had been falsified by the sheriff as part of the conspiracy against him. Well, naturally, this claim raises the concern that the plaintiff was bonkers, but there was no evidence aside from his bizarre claims of that. In court, the case was decided on two alternate grounds. First, on the boring grounds that the case was patently frivolous and vexatious because it was absurd. However, it was also decided on the more entertaining basis of standing. Justice Epstein held that only a person could comment an action in Ontario. The rules of civil procedure define a person to be either a human being or a corporation. The plaintiff's whole case was based on him being a Martian. If he was not a Martian, his case had no merit. If he was a Martian, he lacked standing to commence a lawsuit in Ontario. In short, we now have precedent that Martians cannot sue in Ontario. I won a case where the defendant, New York City, tried to exploit a really stupid law, which I was able to use to win the case. This was a slip and fall case where my client had tripped on a piece of broken sidewalk outside of the Natural History Museum and shattered her arm and wrist. The law is that a property owner is responsible for the sidewalk directly outside of their property, the theory being even if they can't fix it, they have a duty to warn people about hazards and mark the area. The museum was owned by the city. There's another concept called sovereign immunity, which is that governments can't be sued without their consent. So the city had passed a very stupid law that they would be exempted from the rule that they can't be sued for sidewalk injuries unless you can show they were on notice of hazard. Meaning, you would have to show that you informed the Secretary of State / Governor / Mayor, etc. of the exact specific crack in the sidewalk before the injury occurs. And you had to do so in writing with ample time for the city to remedy it 180 days in advance. Under normal circumstances, this is impossible because no one anticipates tripping on the sidewalk 180 days in advance with the foresight to write a letter to the mayor about that specific crack. Luckily, someone did have that foresight, and there was a non-profit called Big Apple Maps, which would go around the city and with maps of government property and record with insane specificity each and every crack in the sidewalk, pothole, protrusion, and other hazard, and then publish these maps while serving copies on the government, with the express purpose of combating sovereign immunity defences in slip and fall cases against the government. I got a hold of one of these maps and visited the site, and I was able to take pictures of the section of the sidewalk where my client fell, and you could see newly placed concrete over the area in the exact position indicated on the map, showing where the sidewalk had been repaired after my client slipped. Basically, the government's attorney brought up the sovereign immunity defence and outlined all of the stupid steps I would have needed to go through to overcome their motion to dismiss. My response was, "Oh, you mean this?" and gave them the map immediate settlement. There was a case here in Hawaii that got thrown out like this. Someone got pulled over because the police saw she had way too many passengers in the car. Then they noticed she was drunk. Open and shut case. Well, apparently in Hawaii, there's no law defining the maximum number of passengers in a private vehicle. So the issue was that all the extra passengers weren't wearing seatbelts. Well, this failed also, because the law only says that every available seatbelt needs to be in use. If you have 6 passengers and only 5 seatbelts, there's nothing at all illegal about the 6th being unrestrained. So, since there was no probable cause to pull her over in the first place, even though she was indefensibly drunk, the whole thing got thrown out. Hawaii has some very counterintuitive laws. If your truck has seats installed in the bed, your passengers must be buckled up. If not, they can just party back there, while anyone in the cab unbuckled would get you a major ticket. People regularly ride down the freeway in truck beds while sitting in lawn chairs. I have one where we won, but didn't quite go as planned. I had a client a while ago who was incarcerated at a state prison farm. Inmates had to spend 40-60 hours a week preparing slop for the hogs from expired restaurant food and cleaning the hog barns. He reeked every time I met with him. Even after showering, he said it was miserable. Well, he found out that some Muslim inmates who couldn't work with pigs were offered to be able to work at the police horse stable instead, 5 minutes down the road. He wanted to sue, saying that stable work is much less revolting than hog work, and that this amounted to unequal punishment on the basis of religion. I thought he had a point. Well, the case didn't get thrown out and actually got some traction. But then the prison changed their policies in response. Inmates who couldn't work around pigs, or didn't want to, would instead be transported to a factory chicken barn the next county over for work each day. He asked that I drop the lawsuit ... and the Muslim inmates were not happy with him. Typical Ian, but the first and only time I ever used the subway station's emergency door to get to the train, the ticket gate wasn't working. It was free. I was a drunk college kid trying to catch the last train home. I got caught by 2 subway officers and given a ticket with a huge attempted fare avoidance fine. I showed up to the hearing in desperation, and they ended up having to drop the fine as they were reviewing the case with me because one cop had recorded that I entered through the right-hand emergency door and the other wrote that I entered through the left-hand emergency door. Never been so grateful in my life. Over 10 years ago, I'd been at fault for rear-ending someone else. I had no insurance and my license had expired. I don't think I need to mention that I was in a very destitute, low place in life, struggling with almost every conceivable aspect of living. The cop was very kind as we talked, but wrote me a ticket for it all. One was kind of a fix-it, ticket about my suspended licence. I sorted that out in the days after, and nothing came of that. The cop had mentioned that he had to write the insurance ticket, but to take it into court and get it lowered. I was desperate to try and get my $800 insurance ticket lowered because I couldn't afford something like. So I took the cop's advice. I went into traffic court weeks later, and when it was my time to chat with the judge in front of everyone there, the judge looked at the ticket, stopped me, and said, "I would like to use Mr. Southseatle's case as an example to the gallery." I almost died. He went on, "This is a court of law, but it is also a court of fairness. It seems as if the officer didn't write the date of the incident in the ticket. I can't hold Mr. Southseatle accountable to this." My jaw dropped. I stood there. The judge told me I was free to go twice before it registered. I'm pretty sure the cop deliberately didn't write the date on that ticket.